California has a heavily regulated late fee framework shaped by strong tenant protections, extensive case law, and local ordinances that add complexity on top of state law. The governing law includes the California Civil Code, significant California Supreme Court and appellate case law, and various local tenant protection ordinances. If you're a landlord or tenant in California, the late fee rules are strict, and getting them wrong can result in significant liability. Let's start with the key principle. California does not have a single statute that caps late fees at a specific dollar amount or percentage. Instead, California relies on its well-developed case law regarding liquidated damages, and the standard is more restrictive than most states. Under California Civil Code Section 1671, a liquidated damages provision in a residential lease is presumed invalid, unless the party seeking to enforce it can demonstrate that it was reasonable at the time the contract was made. This is a critical distinction. In most states, the burden is on the tenant to prove the fee is unreasonable. In California, the burden shifts to the landlord to prove it is reasonable. This reversal of the burden of proof fundamentally changes the dynamic. This means that if a tenant challenges a late fee in California, the landlord must affirmatively demonstrate that the fee was a reasonable pre-estimate of damages at the time the lease was signed. If the landlord can't meet this burden, the fee is unenforceable, even if the amount seems moderate by national standards. California courts have consistently held that late fees must reflect the landlord's actual costs from the late payment, not the amount of rent, not a percentage of rent, and not a round number chosen for convenience. The fee must correspond to documented administrative costs, staff time processing the late payment, generating and sending late notices, additional accounting entries, bank fees, the time value of money, and any other genuine costs directly caused by the lateness. What's considered reasonable in California? Case law and practice suggest that fees in the range of 5 to 6% of the monthly rent, or flat fees roughly corresponding to the landlord's documented costs, are generally defensible. Fees at or above 10% are very risky. A fee of $50 on a $2,000 rent, 2.5%, is easily defensible if supported by cost documentation. A fee of $200 on the same rent, 10%, would be extremely difficult to defend under Section 1671's burden-shifting framework. California does not mandate a specific grace period by statute. There is no state law requiring a defined number of days. However, the practical reality is that virtually every California landlord provides a grace period, and California's legal culture effectively expects one. Most California landlords provide a 5-day grace period. Some provide longer. Charging a late fee on day 2, while not specifically prohibited by statute, would face serious scrutiny from a California court evaluating the overall reasonableness of the fee provision. The lease must clearly state the late fee terms, the fee amount, any grace period, and the conditions for imposing the fee must be documented in the rental agreement. A fee that isn't specified in the lease is not enforceable. Compounding late fees in California face heightened scrutiny under Section 1671's burden-shifting framework. If the landlord must prove that the initial fee is reasonable, proving that additional daily or weekly charges are also reasonable adds exponential complexity. Each additional charge must independently satisfy the reasonableness standard. Most California landlords avoid compounding entirely. A single one-time fee is far safer and simpler to defend. The interaction between late fees and the eviction process in California is critically important. Under California Code of Civil Procedure Section 1161, the landlord must serve a 3-day notice to pay rent or quit for non-payment. The 3-day notice is one of the most strictly construed documents in California landlord-tenant law. The amount demanded must be exactly right, no more, no less. California courts have repeatedly held that a 3-day notice that demands even $1 more than what is actually owed is defective, and a defective notice invalidates the entire eviction case. The landlord must start over with a corrected notice. This means including non-compliant late fees in the 3-day notice can kill the eviction. Whether late fees can be included in the 3-day notice at all is a contested issue in California. Many California attorneys advise against including late fees in the 3-day notice, even compliant ones, because the risk of the fee being challenged and the notice being invalidated is too high. The safer approach is to demand only the unpaid rent in the 3-day notice and pursue late fees as a separate claim. This practical reality means that late fees in California serve primarily as an administrative cost recovery charged during the tenancy, not as a tool that integrates with the eviction process. The eviction process runs on the rent obligation alone. California's Tenant Protection Act, AB 1482, interacts with late fees indirectly. The Act's just cause eviction protections mean that landlords cannot terminate a tenancy without cause for tenants who have been in the unit 12 months or more. A pattern of imposing aggressive late fees designed to push a tenant out could be challenged as constructive eviction or as a violation of the Tenant Protection Act's spirit. California's rent control ordinances in various cities add additional context. In Los Angeles, San Francisco, Oakland, Berkeley, San Jose, Santa Monica, West Hollywood, and dozens of other cities with rent control, the overall landlord-tenant regulatory environment is heavily regulated. While most local rent control ordinances don't specifically address late fees, the enforcement culture in these jurisdictions means that every landlord practice, including fee enforcement, is subject to heightened scrutiny. San Francisco's Rent Board, for example, does not regulate late fees directly, but tenants who believe they've been charged excessive fees can seek advice from the Rent Board or from the San Francisco Tenants Union, which may help them challenge the fee under state law. California's Consumer Legal Remedies Act, Civil Code Section 1750 and following, and the Unfair Competition Law, Business and Professions Code Section 17200, provide additional enforcement mechanisms. These broad consumer protection statutes can be used to challenge late fee practices that are unfair, deceptive, or unlawful. Section 17000 is particularly powerful because it can be used to challenge any business practice that violates any law, meaning a late fee that violates Section 1671 can also be challenged under Section 17000 with the additional remedies that statute provides. For tenants receiving Housing Choice Voucher Assistance, California landlords cannot charge late fees when the Housing Authority's portion is delayed. California prohibits source of income discrimination under Government Code Section 12955. Landlords cannot discriminate against voucher holders. Penalizing a voucher tenant for the authority's processing delay creates both a late fee violation and a discrimination claim under one of the broadest fair housing statutes in the nation. California limits the security deposit to 2 months' rent for unfurnished units and 3 months' rent for furnished units. The deposit must be returned within 21 days with an itemized statement of deductions, including copies of receipts for amounts over $125. Unpaid late fees can be deducted, but only if the fees are compliant with Section 1671 and were properly documented in the lease. Deducting non-compliant fees from the deposit creates liability for up to twice the deposit amount in bad faith cases. California's military population is enormous, including Naval Base San Diego, Camp Pendleton, Edwards Air Force Base, Travis Air Force Base, Beale Air Force Base, Fort Irwin, Naval Air Weapons Station China Lake, multiple Navy and Marine installations, and many others. Military BAH rates for California, particularly San Diego, the Bay Area, and Los Angeles, are among the highest in the nation. Military pay is predictable, and most military tenants pay reliably. SCRA protections apply to all active duty service members. From a practical standpoint, California has the largest rental market in the country, with dramatic variation between regions. Los Angeles is the largest rental market in the nation by total units. The RSO-covered market has its own dynamics, and late fees on rent-stabilized units face particular scrutiny because tenants in these units are more likely to be represented by tenant advocacy organizations. Late fee enforcement in LA should be conservative and well documented. San Francisco has some of the highest rents in the country. A conservative late fee, 5% or less, on a $3,000 rent still produces $150. But defending that fee under Section 1671's burden-shifting framework requires documented costs in that range, which is achievable for a property management operation with staff, systems, and overhead. San Diego's military-heavy market provides reliable tenants. Sacramento has experienced strong growth. The Bay Area, Oakland, San Jose, Berkeley, has extensive local regulation. The Central Valley, Fresno, Bakersfield, Stockton, has more affordable markets. Orange County, the Inland Empire, and San Bernardino County have growing markets with varying rent levels. The coastal communities from Santa Barbara through San Luis Obispo have premium rents. One best practice for California landlords: document your actual costs for processing late payments before setting your late fee. California's burden-shifting framework means you must prove the fee is reasonable, not just assert it. Calculate your staff time at a reasonable hourly rate. Add bank fees, postage for late notices, additional accounting entries, and any other direct costs. Set your fee at or near that documented total. Keep the documentation on file. You may need it. Another best practice: do not include late fees in the 3-day notice to pay rent or quit. The risk of invalidating the notice and losing the entire eviction case outweighs the benefit of including the fee. Demand only the unpaid rent in the notice. Pursue late fees through a separate claim or deduct them from the security deposit at move-out. A third best practice: provide a grace period of at least 5 days and document it in the lease. While California doesn't mandate a grace period by statute, providing one strengthens the overall reasonableness of your fee provision. A landlord who provides no grace period and charges the maximum defensible fee simultaneously is pushing both limits, which is riskier than being reasonable on both. 5 days is the California industry standard. For the complete guide to California late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.